All right, so we'll pick up from the last topic, of course, Rule 1. We're now on Rule 2, Cause of Action. It is the same author, reviewer by M. Riguera. What is a cause of action? It is the act or omission by which a party violates a right of another. Section 2, Rule 2. The facts which give rise to a right of action. This is from Stephen H. Griffith's Law Dictionary, page 30, 1975. A cause of action implies that there is some person in existence who can bring suit and also a person who can lawfully be sued. Douglas versus Beasley, 40 a la 148. Also, the formal statement in a pleading of such act or omission. Multi-Realty Development Corporation versus Makati Tuscany Condominium Corporation, GR 146726. 2016, no, June 16, 2006. In the latter sense, it is used interchangeably and synonymously with claim. Q. What is the importance of a cause of action? Every ordinary civil action must be based on a cause of action. Otherwise, the complaint may be dismissed for failure to state a cause of action, or a judgment may be rendered against the plaintiff for lack of cause of action. Also, a party may not institute more than one suit for a single cause of action. Section 3, Rule 2. Define the following terms: right of action, relief, remedy, subject matter. Letter A. Right of action. The remedial right or right to relief granted by law to a party to institute an action against a person who has violated his right, the legal right to sue. Relief means the redress or other measure which a plaintiff prays the court to order or adjudicate in his favor. Remedy, the form or type of action which the plaintiff may avail of in order to obtain relief from the court. Subject matter, the thing, act, contract, or property which is directly involved in the action concerning which the wrong has been done. Q. Illustrate the foregoing terms. Plaintiff lent 500,000 to defendant. The loan is secured by a real estate mortgage executed by X in favor of the plaintiff. The defendant failed to pay the loan on the due date despite demand from plaintiff. Cause of action: the defendant's non-payment of loan on due date. Right of action: the substantive right on the part of the plaintiff to sue for redress. Remedies: action for collection of sum of money against the defendant. Action for foreclosure of the real estate mortgage against the mortgager. Relief: payment of the loan, foreclosure of the real estate mortgage, and damages and interest under Article 2209 Civil Code. Subject matter: the contract of loan between the plaintiff and the defendant. Distinguish a cause of action from a right of action. The term right of action is the right to commence and maintain an action. In the law of pleadings, right of action is distinguished from cause of action in that the former is a remedial right belonging to some persons, while the latter is a formal statement of the operational facts that give rise to such remedial right. The former is a matter of right and depends on the substantive law, while the latter is a matter of statute and is governed by the law of procedure. The right of action springs from the cause of action but does not accrue until all the facts which constitute the cause of action have occurred or have accrued. Multi-Realty Development Corporation versus Makati Tuscany Condominium, that is GR 146726, June 16, 2006. Right of action is the legal right to sue, while cause of action is the facts which give rise to right of action. That is from Stephen H. Griffith's Dictionary. Hence, in reference to a prescriptive period to bring an action, it is more precise to say that the period starts to run from the accrual of the right of action, not from the accrual of the cause of action. Q. May there be a cause of action without a corresponding right of action? Yes, there may be a cause of action, but with no right of action, if the latter is barred by prescription. That is from Bouvier's Law Dictionary. For instance, the maker did not pay a promissory note, but no action was brought within 10 years from the time the note became due and demandable. Q. Is there a cause of action in proceedings for declaratory relief? Yes, because of the expanded concept of cause of actions in proceedings for declaratory relief. The concept of cause of actions in declaratory relief is not, as in ordinary civil action, the wrong or delict by which the plaintiff's rights are violated, but is extended to a mere denial, refusal, or challenge, raising at least an uncertainty or insecurity which is injurious to plaintiff's right. Multi-Realty Development Corporation versus MTC Condominium or Corporation. It is permitted on the theory that courts should be allowed to act not only when harm is actually done and rights jeopardized by physical wrongs or physical attack upon existing legal relation, but also when challenge, refusal, dispute, or denial thereof is made amounting to a live controversy. Q. What is meant by splitting a cause of action? It is when a party institutes more than one suit for a single cause of action. Section 3, Rule 2. Q. What is the effect of splitting a cause of action? The filing of one is a ground for the dismissal of the others, or litis pendentia. A judgment upon the merits in any one is available as a ground for the dismissal of the others, res judicata. Q. SRBI mortgaged several parcels of land to Metrobank as security for its loan. Then SRBI and Metrobank entered into a credit line agreement with the same mortgage properties as collateral. SRBI defaulted and Metrobank filed a petition for extrajudicial foreclosure of the mortgage. Subsequently, Metrobank filed an action for collection of money arising from the export bill purchases under the credit line agreement. Metrobank bought the properties at the foreclosure, but the bid price was below SRBI's obligations. SRBI moved to dismiss the action for collection of the ground that, or on the ground that Metrobank is splitting its cause of action. Should the motion to dismiss be granted, the answer is yes. Under Act 3135, the mortgage creditor, in case of insufficiency of the proceeds of the foreclosure sale, is entitled to claim the deficiency from the debtor. However, the action filed by Metrobank was not an action to recover the deficiency, but an action for collection of specific performance, which was barred by the election of the remedy of foreclosure. The same should thus be dismissed without prejudice to Metrobank's institution of an action for recovery of the deficiency. Sui Kuratan and Buli versus Court of Appeals. Q. P sued D for specific performance of a contract. The court decided in favor of D and dismissed P's complaint. After the dismissal had become final, P sued D to have the same contract reformed to make it conform to their true intent and to recover upon the reformed contract. Is the second action barred by res judicata? Yes. P only had one cause of action on the contract, whether as written or as reformed, which he could have stated in the alternative pursuant to Section 2, Rule 8. P thus split a single cause of action. Antonio Bautista Remedial Law, Quizer 123. Q. Petitioner filed with the CFI a complaint against the private respondent in 1969 for quieting of title with damages, wherein the former seeks to be declared the owner of the subject land. In 1970, the private respondent dispossessed petitioner of the land in question and stayed there until January 1978. The private respondent won in the CFI, but the CA reversed and declared the petitioner as the owner of the subject land and ordered the private respondent to pay petitioner 56 pesos and 40 cents as the latter's share in the proceeds of the sale of the copra from the coconuts harvested in the land. The decision became final and executory in February 2, 1978. In February 6, 1978, petitioner filed a second case with the CFI against private respondent, seeking to recover from the latter the incomes from the subject land from 1970 up to January 1978 when possession of the land was delivered to the petitioner. Private respondent filed a motion to dismiss the second case on the ground of res judicata. Should the motion be dismissed? Or should the motion to dismiss be granted? Yes. The petitioner was pleading his cause of action when he filed the second case, for both the first and the second case involved the same cause of action. The petitioner would draw a distinction between the land in dispute in the first case and the income from that land being claimed in the second case. But that is splitting hairs to split a cause of action. The subject matter is essentially the same in both cases, as the income is only a consequence or accessory of disputed property. It cannot be said that there are two causes of action calling for two separate cases. The claim for the income from the land was incidental to and should have been raised by petitioner in his earlier claim for ownership of the land by filing a supplemental complaint. Bayang versus Court of Appeals, 148 SCRA 91. Otherwise put, such claim is but the result of the original cause of action, viz. The continuing refusal by the private respondent to recognize petitioner's ownership over the property. See Jalandoni versus Martin Guanzon, 102 Phil 859. It should also be noted that under Section 47, letter B of Rule 39, a judgment of or final order is conclusive between the parties with respect to the matter directly adjudged or as to any other matter that could have been raised in relation thereto. Francisco and Piero died intestate. His surviving spouses or spouse and 5 of his children executed a deed of declaration of heirship and sale wherein they stated that they are the sole heirs of Francisco and wherein they sold the inherited land to the petitioners, the spouses Selga, claiming that he is a legitimate child of Francisco and that the declaration of heirship and sale petrited him. Respondent filed a complaint against the petitioner for annulment of sale and damages with the RTC, Civil Case 276, with respect to his share in the land sold. Respondent also prayed therein that he be allowed to exercise the right of legal redemption with respect to the share of the other co-heirs sold to the petitioners. The RTC granted the annulment of the sale with respect to respondent's 1/11 share. However, there was nothing in the decision with respect to the prayer for legal redemption. Respondent appealed the decision in Civil Case 276, but later on withdrew his appeal, resulting in the decision therein becoming final and executory. Subsequently, respondent filed a complaint for legal redemption, Civil Case number 573, with respect to the 10/11 share of the land sold to the petitioners. Petitioners filed a motion to dismiss on the ground of res judicata. Should the motion be granted, would your answer be the same if respondent had not included a relief for legal redemption in his complaint? The answer to letter A is yes. Section 2, Rule 2 defines a cause of action as the act or omission by which a party violates a right of another. The cause of action in Civil Case number 276 and Civil Case 573 is the sale of the entire subject property by Basilia et al. To petitioners without respondent's knowledge and consent, hence depriving respondent of her rights and interest over her pro indiviso share in the subject property as a co-heir and co-owner. The annulment of the sale of respondent's share in the subject property, the legal redemption by respondent of her co-heirs shall sold to petitioners, and the claim for damages should not be mistaken to be the causes of action, but they were the remedies and relief prayed for by the respondents to redress the wrong allegedly committed against him or her. Hence, the withdrawal by respondent of his appeal from the RTC decision in CC 276, which did not grant redemption to respondent, with the result that the judgment therein became final and executory, precluded the respondent from filing CC 573 for legal redemption, since the latter was barred by res judicata. Selga versus Brar, September 2011. Number 2, yes, my answers would be the same. Res judicata would apply regardless of whether or not respondent had prayed for legal redemption in his complaint. Under Section 47, letter B of Rule 39, a judgment is conclusive between the parties with respect to the matter directly adjudged or as to any other matter that could have been raised in relation thereto. The relief of legal redemption is a matter that could have been raised in relation to the case. Q. Riviera Golf Club, or RGC, and CCA Holdings entered into a 5-year management and royalty agreement whereby RGC agreed to pay CCA monthly management and royalty fees for operating and managing the Rivera Golf Club. Just 3 years into the contract, RGC predeterminated the same on the grounds of financial difficulties and alleged violation by CCA of the agreement. CCA filed with the RTC of Makati a complaint for collection of unpaid management and royalty fees for services rendered against RGC. The parties entered into a compromise agreement, which became the basis of a compromise judgment by the court. The compromise agreement contained a no waiver clause, wherein the compromise agreement shall not be considered as a waiver of and is without prejudice to CCA's cause of action arising from the pre-termination of the management and royalty agreement. Subsequently, CCA filed a second complaint against RGC for the expected business profits it should have derived from the unexpired 2-year term of the agreement but did not because of the pre-termination of the agreement. RGC filed a motion to dismiss on the ground of res judicata. CCA opposed the motion on the grounds that A. The two cases involved different cause of action, and B. The parties had stipulated in the no waiver clause that the compromise agreement was without prejudice to CCA's cause of action arising from the pre-termination of the management and royalty agreement. Should the motion to dismiss be granted? The answer is yes. Both the first and the second cases involve the same cause of action, that is, the breach of RGC of the management and royalty agreement. CCA confuses the relief sought, or collection of the unpaid management and royalty fees, and the claim for the unexpected or expected profits for the unexpired 2-year term, with cause of action. A cause of action may give rise to several reliefs, but only one action can be filed, that is, a single cause of action, or entire claim or demand cannot be split up or divided into 2 or more different actions. Hence, the single cause of action gave rise to 2 relief which should have been sought by CCA in the first complaint. Hence, CCA was splitting its cause of action when it brought the second complaint. The stipulation is void, for it is, in effect, allows the plaintiff, CCA, to split its cause of action. The provisions on res judicata and against splitting of cause of action are based on public policy. Hence, the stipulation is repugnant to public policy and is thus void and unenforceable. Q. Nasugatan sued Sagasa for injuries he suffered when Sagasa drove his car recklessly and bumped into Nasugatan. Sagasa confessed judgment and was adjudged to pay 5,000. Nasugaran became blind because of the injuries he sustained in the accident. He filed another suit against Sagasa, this time for 100,000. May Sagasa plead the filing of the first complaint in abatement of the second suit and contend that the judgment on the merits in the first case constitutes a bar in the second. Explain. This was in Act 86 bar. Question number 1. Yes, Sagasa may plead that the judgment in the first case constitute a bar in the second. Under Section 4, Rule 2, if two suits are instituted on the basis of the same cause of action, a judgment upon the merits in any one is available as a ground for the dismissal of the other. Here, the second suit involves the same cause of action, Sagasa's reckless driving, which violated the right of Nasugadan. In other words, Nasugadan's blindness resulted from the same reckless act of Sagasa. Hence, the second suit is barred by the judgment in the first suit. P filed with the RTC an action reivindicatoria over a parcel of rice land against D, alleging that the same was sold to him by the rightful owner, as and praying that he, P, be declared the owner of the land and that D deliver possession to him. D filed an answer in which he also counterclaimed for moral and exemplary damages for the unwarranted filing of the suit by P. During the pendency of the case, P dispossessed D of the subject land and proceeded to harvest the rice. Judgment was rendered by the RTC dismissing P's suit. The judgment became final. P delivered possession back to D. D then filed an action before the RTC against P, seeking to recover the value of the rice harvested by P. P filed a motion to dismiss on the ground of res judicata. Should the motion to dismiss be granted? In this case, no. The claim for recovery of the harvested rice need not be set up in the first case, as such claim is not compulsory, having been acquired by D after serving his answer. Hence, the claim is not barred, even if not set up in the first case. S 8 and 9, or Section 8 and 9 of Rule 11. Namarco versus Federation of United Namarco Distributors, 49 SCRA 238. It could be made subject of a separate case. Banco de Oro Universal Bank versus Court of Appeals, DR 160354, August 2005. In 1992, respondent's father, Rafael, obtained from the petitioner a loan of 160,000 with monthly interest of 5%, payable within 6 months, and secured by a real estate mortgage. Rafael failed to settle his loan upon maturity despite demands, and thus petitioner filed a complaint for judicial foreclosure of REM with the RTC. The RTC issued a 30-day on January 30th, 1998 decision reducing the interest rate from 5% per month to 12% per annum and ordering Rafael to pay the petitioner 229,000. Records did not show whether this decision attained finality. Meanwhile, prior to Rafael's notice of the above decision, respondent agreed to pay Rafael's obligation to petitioner, which was pegged at 689,000. After making a total payment of 400,000, he executed a promissory note dated February 20, 1998, binding himself to pay on or before 31st of March 1998 the amount of 289, representing the balance of the agreed financial obligation of his father to petitioner. After learning of the January 30th, 1998 decision, respondent refused to pay the amount covered by the promissory note despite demands, prompting petitioner to file a complaint for sum of money and damages before the court, the RTC, in July 1998. Respondent filed a motion to dismiss the collection case, arguing that it involved the same cause of action as the foreclosure suit. Should the motion to dismiss be granted? Yes. The petitioner, as creditor mortgagee, instituted an action for judicial foreclosure in order to recover on Rafael's debt. The availment of such remedy bars recourse to the subsequent filing of a personal action for collection of the same debt. In this case, under the principle of litis pendentia, considering that the foreclosure case only remains pending as it was not shown to have attained finality. While the ensuing collection case was anchored on the promissory note executed by respondent, who was not the original debtor, the same does not constitute a separate and distinct contract of loan, which would have given rise to a separate cause of action upon breach. The reasons are that A. The consideration for the subject promissory note, or PN, was the same consideration that supported the original loan obligation of Raphael, and B. Respondent merely assumed to pay Raphael's remaining unpaid balance in the latter's behalf, that is, as Raphael's agent or representative. Hence, the subject PN did not give rise to a separate cause of action. Marilag versus Martinez, July 22, 2015. P and D entered into a contract whereby B will supply P from month to month with gas power at the price of 65 pesos per ton. The contract was to turn or to run for 10 years. Starting from 1919, D began delivering, but in 1920 flatly refused to make any deliveries under the contract. In 1923, P brought an action for damages against D. P was awarded damages up to 1923. The judgment became final and executory. Later, P brought an action to recover damages from 1924 up to 1929. D filed a motion to dismiss the suit on the ground of res judicata. Should the motion to dismiss be granted? The answer is yes. P, in bringing the second suit, had split his cause of action. As a general rule, a contract to do several things at several times is divisible, and a judgment for a single breach of a continuing contract is not a bar to a suit for subsequent breaches. Where, however, the obligor manifests refusal to perform not only one prestation but all the other prestations, the contract is entire and the breach total and constitutes only one cause of action. Blossom and Company versus Manila Gas Corporation, 55 Phil 226. P in 1923 could thus bring an action for damages up to 1929 under the principle of anticipatory breach, since D in 1922 had made flat or outright refusal to make any delivery under the contract. Q. What is the principle of anticipatory breach? It is the principle wherein a divisible contract or one contemplating divisible prestations or prestations over a period of time, and there is a breach of one prestation. The obligee may bring a suit not only for the current prestation but even for the future prestations, if it is clear that the obligor can no longer or will no longer perform the future prestations. Q. In the prior problem concerning the gas star contract, what if D in 1920 failed to make further deliveries but without any flat or outright refusal to make any delivery under the contract? Should the motion to dismiss by D be granted? No, since the principle of anticipatory breach does not come into play, hence each single breach of the divisible obligation is a separate and distinct cause of action. Q. Plaintiff ordered 2 units frequency converter inverter from defendant to be delivered within 8 to 10 weeks from the opening of the letter of credit or until November 19, 1997. On November 9, 1997, defendant informed plaintiff that it was having problems with its supplier regarding the delivery of the units and it was looking for another supplier, and that at that moment there was no clear message when normal production would resume. Due to this information, the plaintiff surmised that defendant would not be able to deliver the units on time, and hence the plaintiff canceled the order. Plaintiff filed an action for damages against defendant, averring the foregoing facts. The defendant filed an answer raising the affirmative defense of failure to state a cause of action. Should the affirmative be granted? Answer is yes. When plaintiff sued defendant for damages, the latter had not violated any right of plaintiffs from which a cause of action had arisen. Plaintiff only surmised that defendant would not be able to deliver the units on time, and based on this apprehension, it canceled the order. The principle of anticipatory breach laid down in the textbook case of Blossom and Company versus Manila Gas Corp is not applicable here for the same only applies to a divisible contract, supply of gas for 10 years, where the obligor or had manifested his refusal to comply with future periodic obligations. Here, the obligation was single and indivisible to deliver 2 units of frequency converter or inverter by November 19, 1997. Danfoss versus Continental Cement Corporation. Q. Lessor entered into a lease agreement over agricultural land with lessee in 2000. The lessee often made delayed rental payments and even missed some altogether. On March 1st, 2010, lessor sent a demand letter to lessee to vacate the premises, which lessee did not heed. Lessor thus filed an unlawful detainer case in the MTC against lessee. Subsequently, lessor also filed with the RTC a complaint for sum of money to recover the rentals in arrears from January 2003 to February 2010. Lessee filed a motion to dismiss the RTC case on the ground of lease pendants, stating that both cases involve the same cause of action and hence such rentals in arrears should be recovered in the unlawful detainer case. Should the motion to dismiss be granted? The answer is no. Both cases involve different cause of action. In unlawful detainer, the recoverable damages are reckoned from the time the possession of the property becomes unlawful. Since the cause of action is the lessee's refusal to vacate despite demand. Here, the demand to vacate was made only on March 1st, 2010. Thus, it was only after said demand that lessee's continued possession of the leased properties become unlawful. Prior to the lapse of the 15-day period to vacate the property, as stated in the demand letter, the damages sustained from January 2003 to February 2010 do not have a direct relation to lessor's loss of material possession, since they do not result from lessee's refusal to vacate the leased premises. These damages must be claimed in an ordinary action, as in the complaint for collection of sum of money. La Have Agricultural Management and Development Corporation versus Javillana or Javillana, November 7, 2018. Section 5. Joinder of Cause of Action. What are the rules governing joinder of causes of action? A party may in one pleading assert, and the alternative or otherwise as many causes of action as he may have against an opposing party, subject to the following conditions, and we can use the keyword JISM. The party joining the causes of action must comply with the rule on joinder of parties under Section 6, Rule 3. Number 2, the joinder must not include special civil actions or actions governed by special rules. Number 3, if the causes of action are between the same parties, but the causes of action pertain to different venues or jurisdictions, the joinder may be allowed in the RTC provided that one of the causes of action falls within its jurisdiction and the venue lies therein. If the claims in all the causes of action are principally for recovery of money, the aggregate amount claimed shall be the test of jurisdiction. Section 5, Rule 2. Q. What is the reason for the requirement under Section 5, letter B, Rule 2, that the joinder of cause of action must not include special civil actions or actions governed by special rules? In order to avoid confusion in the conduct of the proceedings as well as in the determination of the presence of the requisite elements of each particular cause of action. Florence D. Regalado, Remedial Law. What is the Totality Rule? It is the rule under joinder of causes of action which states that if the claims in all the causes of action are principally for recovery of money, the aggregate amount claimed shall be the test of jurisdiction. Section 5, letter D, Rule 2. Q. When may persons join as plaintiff or be joined as defendants in one complaint? All persons in whom or against whom any right to relief in respect to or arising out of the same transaction or series of transactions is alleged to exist, whether jointly, severally, or in the alternative, may, except as otherwise provided in these rules, join as plaintiffs or be joined as defendants in one complaint. where any question of law or fact common to all such plaintiffs or to all such defendants may arise in the action. Section 6, Rule 3. Section 6, Rule 3 provides for the rules on joinder of parties. Is joinder of parties mandatory or permissive? It is permissive. The caption of Section 6, Rule 3 is permissive joinder of parties. Section 6, Rule 3 also states that the person may join as plaintiffs or be joined as defendants. What is the meaning of transaction as used in Section 6, Rule 3? Transaction as used in Section 6, Rule 3 means whatever may be done by one person which affects another right and out of which a cause of action may arise, and the term series of transactions is equivalent to transactions connected with the same subject of the action. This is from Ricardo J. Francisco Civil Procedure 102. Hence, transaction is not limited to agreements or contracts but also includes acts, omissions, or facts out of which the cause of action arises. Peter, the owner of a parcel of land, files a complaint for recovery of possession against 30 persons who each occupy a separate and distinct portion of the land. Is the joinder of defendants proper? The answer is yes. The action arises out of the same transaction, that is, the occupancy by the defendants of Peter's land. The Supreme Court has implicitly held that the word transaction refers not only to contract but to an occurrence. See Pantranco North Express versus Standard Insurance, March 16, 2005. Evidently, there is a common question of law whether or not the defendants have the right to hold possession as against Peter. P. A Manila resident filed a complaint against D, a resident of Iloilo City in the RTC of Manila. The complaint joins two causes of action, one for collection of 500,000 and the other for title to real property in Iloilo City with an assessed value of 20,000. Both causes of action being unrelated to each other. Was there a proper joinder of causes of action? The answer is yes. Where the causes of action are between the same parties but pertain to different venues or jurisdiction, the joinder may be allowed in the RTC provided one of the causes of action falls within the jurisdiction of the RTC and the venue lies therein. Section 5, letter C, Rule 2. Here, the sum of money case falls within the jurisdiction of the RTC of Manila and the venue lies therein. The fact that the causes of action are unrelated to each other does not affect the propriety of the joinder of causes of action. There is no need to comply with the rule on joinder of parties since the causes of action are between the same parties. P filed a complaint in the RTC of Manila. The complaint joins two causes of action, one for recovery of 350,000 against D and another for specific performance against E, D's friend, based on E's undertaking that he will assign certain shares of stock in favor of P if D defaults in the payment of the loan. Assume that the joinder of D and E as defendants complies with Section 6, Rule 3. Was there a proper joinder of causes of action? The answer is no. There was no proper joinder of causes of action. While one of the causes of action, the one regarding specific performance, which is incapable of pecuniary estimation, falls within the RTC jurisdiction, the other involving recovery of 350,000 does not. Hence, the latter should be severed from the complaint. The rule under Section 5, letter C, Rule 2 applies only where the causes of action are between the same parties. Here, the causes of action are not between the same parties since one cause of action is against D while another is against E. Hence, the joinder is not allowed because one cause of action falls outside the RTC's jurisdiction. P seeks to recover 350,000 from D. P also entered into a contract for services with D. However, D has breached a material provision of the contract for services. P filed a complaint against D before the MTC of Manila, wherein he joins the causes of action for recovery and for rescission. Should the joinder of causes of action be allowed? The answer is no. The joinder of causes of action should not be allowed. While the MTC has jurisdiction over the cause of action involving recovery, it has no jurisdiction over the cause of action involving rescission, which is incapable of pecuniary estimation. Hence, the cause of action involving the rescission should be severed. Note that the provision allowing joinder of causes of action, which pertains to different jurisdictions under Section 5, letter C, Rule 2, applies only if the joinder is in the RTC. P files a complaint against D with the RTC of Manila wherein he joins two causes of action, one for collection of loan in the amount of 450,000 and another for collection of a loan in the amount of 350,000. Was there a proper joinder of causes of action? The answer is no. Under Section 5, letter C of Rule 2, the joinder shall not include actions governed by special rules. Here, the action for collection of 350 is governed by the rules of procedure for small claims cases, since it does not exceed 400,000. Hence, the joinder of causes of action is improper. Same facts as in the preceding question, except that the second cause of action is for recovery of damages amounting to 350,000 arising from quasi-delict. Was there now a proper joinder of causes of action? The answer is yes. The second cause of action would not be covered by the RSCC since claims for damages arising from fault or negligence have been removed from the coverage of the RSCC, or the rules of procedure for small claims cases, nor is it covered by the rule on summary procedure since the amount of the claim or demand exceeds 200,000. Hence, there was a proper joinder of causes of action. P files a complaint against D with the RTC of Manila where he joins two causes of action, one for collection of a loan of 350,000 and another for collection of another loan in the amount of 200,000. D files a motion to dismiss on the ground of lack of jurisdiction. Should the motion to dismiss be granted? Of course. Under Section 5, letter C, Rule 2, the joinder shall not include actions governed by special rules. Here, both causes of action are governed by a special rule, that is, the rule of procedure for small claims cases. Hence, the joinder of causes of action is not proper, and consequently, the totality rule cannot come into play. The RTC would not have jurisdiction since the claim in each cause of action does not exceed the jurisdictional amount of 400,000. Perry is a resident of Manila while Ricky and Marvin are residents of Batangas City. They are co-owners of a parcel of residential land located in Pasay City with an assessed value of 100,000. Perry borrowed 450,000 from Ricky, which he promised to pay on or before December 1, 2020. However, Perry failed to pay his loan. Perry also rejected Ricky and Marvin's proposal to partition the property. Ricky filed a complaint against Perry and Marvin in the Regional Trial Court of Pasay City for the partition of the property. He also incorporated in his complaint his action against Perry for the collection of the latter's 450,000 loan plus interest and attorney's fees. State with reasons whether it was proper for Ricky to join his causes of action in his complaint for partition against Perry and Marvin in the Regional Trial Court of Pasay City. 2005, bar question 3. It was not proper for Ricky to join his causes of action in his complaint for the following reasons. 1. Under the rules of civil procedure, the joinder shall not include special civil actions, Section 5B, Rule 2. Here, one of the actions joined is for partition, which is a special civil action. Hence, the joinder was improper. Number 2. Under Section 5, letter A, Rule 2, in relation to Section 6, Rule 3, the joinder of causes of action must comply with the rule on joinder of parties. Here, the claim against Perry and Marvin for partition and the collection claim against Perry did not comply with the rule on joinder of parties since the claim did not arise from the same transaction or series of transactions, nor is there any common question of law or fact. Section 5, letter A, Rule 2, and Section 6, Rule 3. Finally, the venue of one of the causes of action, that is the one involving the collection of 450,000, is misplaced since none of the parties reside in Pasay City. The exception clause under Section 5, letter C, Rule 2, which provides that the joinder of causes of action may be allowed in the RTC if they pertain to different venues or jurisdictions, provided that one of the causes of actions falls within the RTC's jurisdiction and venue lies therein, is not applicable because the causes of action are not between the same parties. Rafael, a warehouse man, filed a complaint against B Corporation, X Corporation, and Y Corporation to compel them to interplead. He alleged therein that the three corporations claimed title and right of possession over the goods deposited in his warehouse, and that he was uncertain which of them was entitled to the goods. After due proceedings, judgment was rendered by the court declaring that X Corporation was entitled to the goods. The decision became final and executory. Raphael filed a complaint against X Corporation for the payment of $100,000 for storage charges and other advances for the goods. X Corporation filed a motion to dismiss the complaint on the ground of res judicata. X Corporation alleged that Raphael should have incorporated in his complaint for interpleader his claim for storage fees and advances, and that for his failure he was barred from interposing his claim. Raphael replied that he could not have claimed storage fees and other advances in his complaint for interpleader because he was not yet certain as to who was liable thereof. Resolved the motion with reason. Bar question. I would deny the motion to dismiss on the ground of res judicata. An interpleader suit is not based on a cause of action since there is no act or omission by which the defendants violated the right of the complainant. The complainant is simply seeking to compel the defendants to interplead among themselves. Hence, the concept of res judicata in splitting of cause of action would find no application since the complaint is not based on a cause of action. X Corporation's argument that Raphael should have incorporated his complaint for interpleader his claim for storage fees and advances is incorrect, since joinder of causes of action should not include special civil actions like interpleader. May an action for injunction be joined in one complaint together with an action for quieting of title? No. Section 5, Rule 2 provides that the joinder of causes of action shall not include special civil actions. The joinder of an action for injunction with an action for quieting of title is not allowed under Section 5, Rule 2, since the latter is a special civil action. Salvador versus Patricia, November 2016. May interpleader be joined with declaratory relief in one complaint? No. Since both are special civil actions, such joinder would be violative of Section 5, letter B, Rule 2. Bellum Medical Group versus Santos. May a court order a plaintiff to join causes of action? No. A court may not order the joinder of causes of action since there is nothing in Section 6, Rule 2, misjoinder of causes of action, which empowers the court to do so. Compare with Section 11, Rule 3, misjoinder and non-joinder of parties, which provides that parties may be dropped or added by order of the court upon motion of or sua sponte. Jose Feria, 1997, on his Rule of Civil Procedure. And that ends our Rule 2. So we will go to Rule 3, and that should give us another time. If you have not yet subscribed to our channel, go ahead and hit that subscribe button, and we will study together Remedial Law 1 and 2. Thanks.